Okay, it looks like we're good to start. Good afternoon, everyone. My name is Megan, and I'm a student here at the Center for Public Legal Education, or CPLE for short. Welcome to our 1 hour webinar this afternoon, Social Media and the Law. You can see a few other faces on the screen today. Those are our panelists, and I will introduce them in a few moments. First, before we start, CPLE respectfully acknowledges that we are located across Treaty 4, 6, 7, 8, and 10 territories and respects the histories, languages, and cultures of First Nations, Métis, Inuit, and all First Peoples of Canada, whose presence continues to enrich our vibrant community. I also need to make a quick disclaimer. This presentation contains legal information only and is not legal advice. We would also like to thank our funders, the Alberta Law Foundation, the Department of Justice Canada, and the Alberta Real Estate Foundation for making our webinar series possible. A few housekeeping items. First, we will be recording the webinar for on-demand viewing on the CPLE YouTube channel. Second, we'll answer all questions at the end, so please submit them at any time using the Q&A function. And then third, please fill out our short survey when you exit the webinar. So, who or what is CPLE? CPLE is the Center for Public Legal Education Alberta, and our goal is to make the law understandable for Albertans. We are a nonprofit organization serving all of Alberta. We provide legal information and education through various booklets, tip sheets, videos, webinars, websites, and more. Our goal is to make the law available and understandable to empower Albertans to use the law. Here's a snapshot of our website. As you can see, we cover a variety of legal topics, and several of our resources have been translated into French. So now we can get on to the webinar that we're facilitating today, and we can introduce our panelists. First, we have Andrew Skeeth. He is a partner at Reynolds, Mirth, Richards, and Farmer LLP and practices municipal law and labor and employment law. He also represented both plaintiffs and defendants in defamation lawsuits. We also have Andrea McLean today. She is a senior associate at JSS Barristers with a strong focus on defamation law, representing both plaintiffs and defendants in high-stakes reputation disputes. With a background in journalism and litigation experience before the Alberta courts, she brings a strategic and informed approach to complex defamation matters. So, we can get started now with some questions now that we know our panelists. I want to start with Andrew first and ask, what are some common issues Albertans are facing related to social media?
Well, it's a good question. Related to social media and related to our topic today, one of the most common issues I would say that people are familiar with would be, cyberbullying, which we'll talk about a bit later, but it can also, mean online harassment. The other thing which people might encounter are issues around defamatory statements on the internet, most often in the context of posting reviews. We all get asked a million times to post reviews for things. Everything that we use now, you can post a review. And, you do have to be careful about what you put into those reviews. And businesses, on the other side of things, if they get a review they don't like, they may decide to take steps or talk to a lawyer, these sorts of things. And lastly, this one is hopefully rare for most people, but sometimes when you post things online, that can have an impact on your personal life, and specifically can have an impact with your employment. And you can be disciplined, you can be terminated, you can have that impact how you earn a living. So that's something that can happen as well.
Thank you. And we're going to get into a few of the issues you discussed later in the presentation. Andrea, was there anything that your clients are experiencing that Andrew didn't touch on, or is it mostly the same?
I think Andrew certainly touched on the most prevalent ones. Another issue that I've seen come across my desk is sometimes in regards to concerns regarding privacy violations, sometimes called doxing, where somebody provides personal information identifying another individual, their address, along with the defamatory comments, really sometimes triggering a unwelcome response. Trolls online going after individuals who have been doxed. And so I've seen that occur as well. And it seems to be a rising phenomenon, especially when people are able to hide behind the anonymity that comes with being at a keyboard.
Yes, I think I've definitely seen some doxing online myself, especially with influencers. Okay, now moving to our next question. How frequently are issues happening involving social media in your guys' practices? Maybe Andrea can take a shot at this first.
Yeah, so I'm finding that it's actually becoming increasingly common. This is a problem that's not going away. If anything, it's getting worse. Especially with cyberbullying and defamation. I understand that there's some reports from the RCMP indicating that cyber-related complaints are on the rise in the sort of criminal side of things. I certainly am seeing a lot come across my desk. I would say significantly more so in the last 5 years or so. And so you're seeing more of it with more of these. More of them tend to go down the litigation process. And I think that there is a recognition generally in regards to specifically cyberbullying that it is a problem with amongst our youth, and it remains a really significant area of concern. And so much so that the government is starting to take notice. I know that this past year in I think February 2024-ish, the government introduced what is called Bill C-63. It's the Online Harms Act. And it was a framework that was intended to hold platforms accountable for harmful conduct, to try and prevent some of the harm that comes on social media platforms. That bill ended up dying when Parliament was prorogued in January. But it is indicative of the fact that governments are sort of sitting up and taking notice and realizing that there are problems online and are trying to figure out ways to address them.
Thank you. And then from that, I was also wondering, Andrew, since you kind of focus in like more of the employment side, have you been seeing that happening in the workplace more, like social media coming up as an issue?
Yeah, I mean, it does. It like we'll talk about a bit later, but I mean, employees tend to think that they can do whatever they want in their personal lives online and it won't have any impact. But everyone has social media, everyone has, Instagram, X, all of these things, and it's very easy to find out what you're posting. And so employers obviously notice when their employees, especially if you're outside of a larger jurisdiction, employers are aware when you're posting stuff online that's not very kosher or socially acceptable. And usually there will be a reaction. Like I get asked quite often, this is what this person was posting, and here's what they're doing at work. So what can we do about it, right? So yes, I would say it is increasingly prevalent in today's landscape.
Thank you, guys. That makes a lot of sense. I know at my work, when someone calls in sick and then all of a sudden they're on vacation, you have some questions. So, um, moving on to our third question here. This is one I was really curious about. What ways have you seen social media being used to resolve legal disputes, if in any? I thought maybe Andrew could answer this one first.
Sure. Yeah, you're right. I mean, usually, like Andrea said, most often social media is the way these disputes start, not that they're resolved. But when you're dealing with defamation, and I'll just, I guess, to add to what Andrea said about that last question, almost all of the defamation files I've dealt with, like since I started articling, have involved social media in one form or another, whether it's review posts or not. So I would say, yeah, it is the de facto way to communicate for people these days, and it's where all of these, when you communicate in a defamatory fashion, that's where these lawsuits kick up. So it is incredibly common, but it can be used to resolve these kinds of actions, and it often is, in the sense that, let's say, you post a review online about a business and they don't like it, and they send a letter to you and say, hey, this is defamatory, you need to recant and apologize and all these sorts of things. The way you're going to do that is, if you want to agree, is by posting a new review or by amending your own review that you previously posted, right? So the tool that you use to create the reputational damage is the same one that you would use to fix it. And often, as part of a defamation lawsuit, one of the things that can be used as a settlement tool is an agreement to publish an apology. It's not something that a court will order, so it just has to come voluntarily from the parties. And where that apology is posted these days is most often going to be online, on social media, on Instagram, whatever, even if the original defamatory statement was not published online, because what are the alternatives? You're not going to go print off an apology and start taping it to lampposts in the neighborhood, right? So the most common thing, and I'm sure Andrea has probably seen the same thing, is, look, if we agreeing to an apology, I want to post it on your client's Facebook, Instagram, whatever, million other places for a period of 3 months or whatever like that. So it is an important tool in resolving these disputes.
I wouldn't have even thought of that. When I was thinking of this question, I thought maybe like in resolving disputes, social media was like used as evidence, I guess. Like that's not having knowledge in this area, what I thought maybe. Andrew, did you have anything to follow up on that or any other ways it's being used?
Yeah, Andrew really hit the nail on the head with his answer. It's absolutely correct that it is one of the foremost ways to get that apology and retraction publicized in a way that the wronged party wants. In regards to your point on use of evidence, it is an element that is obviously certainly used in any potential claim or claim itself. Is having the screenshots of the defamatory material often is it's evidence for any defamation claim. And I've found in circumstances where there is a significant series of social media posts or messages or videos, when those are all compiled into one place and sometimes included as evidence in perhaps a cease and desist letter, the amount of evidence that is there and usable is sometimes enough to shake the defamer awake and kind of go, oh, like they've got this, and it could potentially be detrimental to me in a claim, and it can sometimes get the discussions going in terms of reaching some sort of resolution.
Thank you. Next, I wanted to get into some areas of the law that engage with social media. So my first thought was defamation. So Andrea, could you tell us what defamation is?
Yeah, it's a good question. I think everybody feels like they know what defamation is if they see something online about themselves that they think is unflattering and go, that's defamatory. But there is a three-part test that is laid out that is required in order to prove defamation. The first is that the statement has to be published to a third party. You can't defame someone to themselves, so you need some sort of third party involved. It has to be about an identifiable individual, and that statement has to lower their reputation in the minds of right-thinking members of society. Once you have those three elements, then you've got defamation proven and reputational damages are presumed. If defamation is proven, then the burden flips to the defendant to prove one of several defenses. You may have heard the statement, if it's true, it's not defamation. Well, if it's true, that's a complete defense to defamation. And so then it would be the defendant's responsibility to prove that what they said was true. Another potential defense is fair comment on a matter of public interest. And that is where often online reviews fall into. The courts have sort of recognized that people can make online reviews and they can fall under the fair comment on a matter of public interest, depending on, of course, the content of the review and a few other elements. There's also the defenses of qualified privilege and absolute privilege, but both of those are less likely to be relevant in a social media context, so I'll sort of leave those aside. If, the fair comment defense, for example, is raised in a defamation matter, then there will be a consideration of malice, and that is if someone posts something out of spite or animosity or to further some sort of ulterior motive, and the individual who is defamed can prove that on a balance of probabilities, then it defeats the ability for the defamer to use the defense of fair comment. It basically wipes out their ability to rely on that as a complete defense. So if you are online posting about a restaurant, but you're doing it because you actually own the restaurant next door and you're trying to get rid of your competition, that's malice. And so while maybe the fair comment defense would apply in another situation, because you're doing it to try and get rid of them, that's malice, and then that would defeat your ability to use the fair comment defense as a way of defending yourself if you were being sued for defamation.
Thank you. That all made sense to me. I did have one question based off of the three criteria. I think you said, I think it was the second one, that it had to be an identifiable party. Does the comment have to say, I'll pick on myself. So two examples. One's like Megan did X, or alternatively, a redheaded girl wearing a gray sweater did X. Does it have to say the name, or can it be just obvious from context who you're talking about?
That's a really, really good question. And it does not need to include a name. The courts are really going to look at whether the recipients of that message are able to identify exactly who it is you're talking about. For example, if I went on my Facebook page and wrote something defamatory about, my husband did X, Y, and Z, and I would never do that, but if I did, everybody receiving that is going to be able to identify who my husband is, or the vast majority of people are going to be able to identify who that person is, given the context. So the burden, of course, is on the plaintiff, the individual who's been defamed, to show that it was sufficient that the receivers of the defamatory comment would be able to identify who they were. If I said, a lawyer I know steals trust funds, I know a ton of lawyers, and that it may not be, likely wouldn't be enough for a court to say, yeah, it's defamatory of X individual lawyer, because it's not specific enough for the recipients to know who it is that I'm talking about without further context.
Perfect. Thank you. That definitely cleared it up for me. So now, moving to the next question, can you guys, I guess you kind of already gave some examples of defamation online, but did you guys want to add anything else, or should we move on?
I can add one that might be more of a personal angle. So just because I think most people listening today are probably thinking about, their own personal experiences. Um, we have a tendency to post things on Instagram or any of these things without thinking like observationally about whatever. And I had a client who uh, got into basically a personal argument, let's say, with one of her former somebody she worked with, essentially. And this person's husband got upset and without talking to his wife, just decided to suddenly go on a rampage on Instagram and posted about like 400 Instagram stories naming our clients and, with all kinds of crazy allegations like she stole, she abused people, she was unethical, and lots of creative insults as well. So, and that prompted litigation. So, I wanted to give that example because I think people have a tendency to think, well, I can go, maybe if I post it as a story, it'll disappear, and then, nobody really needs to worry about that, or nobody can do anything about that. And the reality is, anything you put online is recorded. And most of the time, we're able to get a copy of that and it persists. And screenshots are also very easy to take as well of stories. So, you really need to be careful when you're posting stuff online, and also don't post in a fit of rage. It will never get you anything positive. I can tell you that from experience.
Thank you. That's a good example. Um, I thought we could move to the next question. Um, I had a question of what is someone's options if the post that they made is labeled defamatory? I thought Andrea could answer this question first.
Sure. Now, to address the question itself, when you say labeled defamatory, really the only way that that you determine whether or not something is defamatory, or that you're really given a heads up that your post is may be considered defamatory, usually comes if the person you're speaking about says, "Hey, that's defamatory," or "I think it's defamatory," or you get a correspondence from that individual's lawyer saying as much. So basically, if you've been tipped off that you've posted something that someone considers defamatory, you've got a few options. First, you can remove or edit your post if you're inclined to do that. You can knowing that what the test is, and that if it's something that's likely to lower somebody's reputation, you can revise it. You can issue a retraction and an apology if you have defamed somebody, and practically speaking, that's a mitigating factor, and it really minimizes the damages that a claim that could arise from a claim, and frankly, it may make a claim not worth pursuing at all if you respond quickly enough to issue the apology and retraction, because it can just make the damages that may be awarded related to the defamation so minimal that it's not actually worth anybody pursuing. You could also seek legal advice if you are of the position, for example, that the restaurant review you wrote is fair and a true reflection of your experience, that you may want to seek some legal advice to determine whether it's defensible, or anything that you post, whether it's defensible. That would be a really good step, especially if it's something that you would like to continue to exist online. And from there, your legal advisor can give you some options as far as whether or not it should come down, or whether or not it's something that's defensible, and you can say, no, I'm not going to change this. I think it's fair, and will be willing to defend in the event you bring a lawsuit.
Thank you. I had kind of a follow-up question that I just thought of myself. Um, when a post is labeled defamatory, I was wondering if usually like the example of the review we keep coming back to, is it often the case in these kinds of litigations that the restaurant owner would be represented by counsel and then the person who wrote the post would be like a self-representative person, or do you see them getting counsel a lot of the time?
I can answer that. It depends, right? So most of the time, you're right. I mean, the restaurant owner, the business owners usually reach out to the lawyer and say, "Hey, this is what can I do about this?" And yeah, it depends. The person who posted the review, usually they don't bother to get a lawyer because I mean they have no skin in the game for the most part, right? It's just like, fine, I'll take it down, or I'll just ignore you because I don't really care. And like, what are you gonna do over this small time review, right? So yeah, a lot of the times you do end up with sort of a self-represented defendant, which can be frustrating. But a lot of the times you might be surprised, and a defendant will take a really principled stance for no apparent reason, and they'll go spend money on a lawyer again for to no one's benefit but the lawyers. And you know, so you may get legitimate litigation over something that just should never have gotten that far. Yeah.
Thank you. That was my own curiosity. Moving to the next question. Um, what are your options if it's you and you feel like you were defamed online? So if you're the restaurant owner, let's say, Andrea, did you want to take a shot at that?
Yeah, sure. So the first step should always be to contact the poster. Give notice to the poster immediately that you believe this to be defamatory and ask it to be taken down. If you get a positive response and they do so, you've saved yourself a ton of time, a ton of headache, a ton of money potentially, and that can bring an end to the matter right away. In the event that it is that you are unable to contact the poster, or the poster doesn't respond, or indicates that they're going to keep their defamatory statement up, then you've got to consider if it's worth contacting the platform. The platform like X, Facebook, Instagram, they usually have some sort of community standards. And if it's contrary to the community standards on the platform, you can repost it, you can report it and have it then removed for that. However, a vast majority of the time, I find that the defamatory comments that are posted don't actually fall offside of the community standards. And there seems to be a shift lately in what is permitted on these platforms in terms of favoring free speech rather than pulling down content for being defamatory. So that's less likely now than it was several months ago to be a successful avenue, but it's worth taking a time to look at whether or not it is contrary to the community standards. Because again, if you can get it pulled down that way, it is faster and cheaper than contacting a lawyer, which would probably be your next step if you're unable to get the poster to pull it down, or the platform to pull it down. It'd be to look at contacting a lawyer and talking about your options with a lawyer. It may begin with a cease and desist letter, which is just a demand to take it down, perhaps issuing an apology or a retraction, which Andrew spoke about earlier, that you sometimes seek to have that posted on whichever platform for a period of time to correct and really mitigate the damage to the reputation. There are, of course, some issues in regards to a cease and desist letter. I typically warn my clients that cease and desist letters, in my view, often need teeth in order to be effective because, as Andrew mentioned, you can send a notice to a poster and they can just ignore it unless you've got some sort of, and if you don't, there will be X consequences. And often those consequences are some sort of threat of litigation. However, if you make a threat of litigation saying, if you don't pull this down, we'll sue you, and you don't follow through, then you've got a situation where you very well could embolden the person who has defamed you because they know that you're not actually intending to sue them because you threatened to do so. They didn't do what you wanted, and then you didn't do anything. So, there's these risks. And then, of course, if you do threaten litigation, litigation is a very expensive avenue to go down, and is often not worth it for a lot of the defamation that I see that occurs online. So that's something else that needs to be considered. And then lastly is the concern regarding sending a cease and desist letter can cause issues in its own. I've had situations where we've got someone who's obviously got a immense dislike for the party that they're defaming. A cease and desist letter is then just used as fodder in their online campaign. For example, it's posted in its entirety and goes, now look, this jerk I've been telling you about is now threatening to sue me, to shut me up. And it can lead to further defamation, which of course, then you've got to determine whether to take that next step and litigate the matter.
Thank you. I think you did a good job of thoroughly explaining all of the options. The next question I had was, when is it worth bringing a defamation claim if litigation is expensive?
Almost never.
Well put.
Yeah, I mean, I say that somewhat jokingly, but the reality is that any litigation is very expensive for the parties. And, at the end of the day, the court, especially in defamation, the court will give you basically two things. Damages, which is just a piece of paper which says the defendant owes the plaintiff X amount of money, and you have to go collect it, which is difficult for the vast majority of cases. And meanwhile, you will have to pay your lawyer throughout that entire process. So, financially, it's probably not going to be worth it because the people who are defaming you are usually just random individuals, and they aren't going to have a bunch of assets that you can easily collect against. And the other thing is that ultimately, as Andrea said, defamation is a tort that's aimed at repairing reputational damage. But it's not exactly in step with how I think human beings actually act and think about these things. So when someone posts or says something defamatory about you, you then go blow it up, start a lawsuit, start posting things about it. There's news stories back and forth. That makes the plaintiff often look, if it makes them look like fine, if it says, okay, well, yeah, this lawsuit was legitimate and justified, but nevertheless, people are thinking about it and talking about it. And so you've just basically blown something up which would have disappeared out of the vast majority of people's consciousness in a matter of weeks, if not days or hours, into something that will last probably 5 to 7 years. And if you get a published decision, much longer than that. So you really have to think long and hard. Is this something you want, one, to deal with for 5 to 7 years? Or two, do you want a published decision out there? Even if it vindicates you, you're still, your name and your personal details are going to be out there in a public document for the world to see. So, when you think about all those factors, I would say in the vast majority of circumstances, do what you can to get the post removed to mitigate damages in the short term, but don't seriously contemplate litigation unless it's something so egregious that you just have no choice.
Yeah, and if I can sort of piggyback on that, the egregious element where there's no choice is obviously more than just I'm really hurt, my feelings are hurt, and I feel like people are looking at me different and think less of me. The real life, there's got to be some sort of real life consequences. I find, anyone who's doing this because they think they might get a windfall in terms of monetary damages is really barking up the wrong tree. Defamation awards in Canada are are pretty low in the grand scheme of things, and you stand to pay many times more in legal fees to get to any damages award, much less collecting, as Andrew said. It comes with its own challenge. And where I see sort of some of the real life consequences, places where clients are actually looking to follow through is where there's some obvious loss of income, for example, that is connected, and those are often difficult to prove, but where the facts are such that there are some real life consequences to a business, for example, and that the link to the defamation is clearly made out, and that's a big challenge. Or alternatively, I've seen where the claim is so egregious that you have to bring a response to it, like often in sexual assault cases where someone says, I've been defamed, and my ex, who is angry at me, is claiming that I sexually assaulted her. And of course, that can have some severe real world consequences if that kind of information gets spread around. And so that is where you're considering something that's more than just my feelings have been hurt, and I think people might think less of me. This could actually impact my ability to be hired in the future, to my ability to engage socially in the future. I could become a social pariah, those kind of things. And that's where it actually is worth considering bringing a claim.
Thank you. And then I had a quick question about prevention. What can someone do to kind of shield themselves if they want to leave a review or they want to post something online, but they want to make sure that they're not liable to any threats of defamation?
Sure. I mean, I can answer that quickly. So to begin with, kind of going with the theme of this presentation, before you think you need to post anything online, think long and hard if you really do need to post something online. 99.9% of the time, it's going to be, no, you don't need to post that online. But if we go beyond that, first of all, if it's about an identifiable subject or a person or a business, or let's just start with a person, just think, okay, well, would I want to read this online about myself? If the answer is probably not, that wouldn't paint me in a very good light, don't post it. If it's a straight factual statement, think, yeah, it's justifiably true, it's substantially true, and try to make it as clear cut as possible. If it's a statement of opinion, then make it clear that it is your opinion and actually say that. And obviously avoid any situations where, even if it's your opinion, if you're posting it because you really hate a person or a business or what have you, just don't post it. Because again, this gets to what Andrea was talking about, which has to do with malice, right? So even if it's an opinion or otherwise might be protected by fair comment, if the back current is that you hate this person or this business and they could prove it somehow, then you could be liable in any event.
Thank you. I think that was a good brief answer. And just for the interest of time, I'm going to move on to our next question here. And we're moving on to another topic we introduced a little earlier, cyberbullying. I was wondering if, Andrea, if you would feel comfortable giving a brief definition.
Yeah, similarly, to defamation, I think a lot of people can identify cyberbullying when they see it. It's just the use of digital communication, online, social media, texts, emails, to harass or intimidate or threaten people, like spreading false rumors, providing embarrassing information, sending threats or abusive messages. Those kind of things, revenge porn, that kind of stuff can all be part of that. This became very evident and became part of the public discourse with Amanda Todd several years ago. So there's a lot of discussion in society these days that of what cyberbullying is, and it's basically taking those kind of things that you maybe used to happen on the playground and bringing it into an online setting.
Perfect. Thank you. And earlier, you talked about how the legislature is taking note of this problem. And then I was curious, is there any laws that are taking account of this problem or addressing cyberbullying? Andrew, I think you can answer this one.
Sure. Yeah, well, I mean, there's, cyberbullying, like Andrea said, it's basically harassment, but through digital means, right? And so harassment, broadly speaking, is, unwanted conduct, whether it's physical, verbal, or written. And so, there has been the discussions about this tort of harassment. Defamation is a kind of tort, but then there's been an actual lawyers over the years have tried to get a tort recognized in various provinces just for the freestanding tort of harassment. And in recently in a case called, I think it's Gary Johnson and Alberta Health Services, the Court of King's Bench of Alberta did recognize that this tort existed. As far as I'm aware, it hasn't been confirmed by the Court of Appeal, which means it's questionable if it actually exists. It's really just one justice who said, I think it exists. And, that decision was never appealed. But if it gets up to the Court of Appeal in a different context, we could very easily get a decision by the Court of Appeal, which says, no, that's not a tort in Alberta. So for now, for all of the litigation lawyers, we add it to pleadings and we see what happens with it. But generally speaking, it does exist sort of in an untested way in Alberta. And it's the way it's formulated is there is also a test for this tort of harassment, but it's so broad that you could really throw, I don't have it in front of me, but essentially comes down to, if you've done anything that's harassing or unwelcome, that's repeated, then you could technically shoehorn that into the tort of harassment and then get, the remedies that flow from it. So yes, cyberbullying, that would definitely fit with this tort of harassment. And so you could face civil liability if you actually manage to get to trial and get a judgment based on that tort in a cyberbullying type situation.
If I could jump in a little bit to expand on what Andrew just said. He's right in terms of trying to shoehorn a lot into the tort of harassment. There is one of the elements, and I do have the test in front of me, so that makes it a little easier for me to speak about. But in terms of requiring that there are repeated communications that are unwelcome, there's also the element that the plaintiff should have known that a reasonable person would fear for their safety or their loved ones. So it's got to be a certain level of harassment. So whether they're fearing for their own safety or the safety of their loved ones, or it could cause emotional distress. And then the last element of the test is that it actually has caused harm. So that means that the individual suing, the plaintiff, would have to prove that they've actually suffered some sort of harm as a result of this harassment to be able to meet the test and be able to be successful in that tort. So that is probably it is a relatively new tort, as Andrew said, and I think right now there's sort of a recognition that the requirement that there be harm caused is probably the key area in which the use of this tort is limited, because a lot of people can be like, well, my neighbor's been a jerk and been doing these kind of things for years, but they can't point to any actual harm that they have suffered as a result of this guy, standing in his front yard and yelling. So.
Perfect, thank you. I also want to just acknowledge that the Canadian criminal law actually also deals with cyberbullying in some way, but That's kind of outside of the scope of today's webinar because we don't have criminal lawyers in front of us. I don't want to put anyone on the spot, so I'm just going to move on. And I'm conscious of time, so I'm going to come back to this question at the end if we still have time. I just want to make sure that we can get into the employment questions. And the first question I had related to employment is, can an employer discipline or dismiss an employee based on their social media activity?
So yes, in short, yes. It's more complicated than that. You know, whenever there's sort of this idea where if you have out of work conduct or something that an employee has done, there has to be a sufficient connection between the work and the conduct that the employer could actually use that as justification to discipline and dismiss for cause their employee as a result of that. So can that include some social media activity? Yeah, it absolutely can. Like I mentioned at the beginning of today's webinar, I get asked opinions on, okay, so like, can we discipline? Is there sufficient cause based on this person's Facebook posts or public posts? And it really depends what is being said. But something that you should be aware of is when you're posting stuff online, if you are an employee, you're working somewhere, if your account notes that you work at that specific, office or employer or what have you, and then you're using that same account to post things, your own public views, that in itself is a problem because there is an implicit connection between your views and the views of your workplace. So one of the things that you would do is make sure your account does not reference your employer at all, so that on the face of it, it's your personal views. And the second thing you can do is that whenever you post something online, you should actually explicitly say, these reflect my views and not the views of my employer or any other organization or entity. At least on the face of it, then it's purely personal. And that's not necessarily going to help you in certain cases. Usually those situations are where the employer is posting about things which are just completely, or the employee is posting about things which are just completely unacceptable. Like if you're posting about the Holocaust or some sort of conspiracy theories about those sorts of things, almost every employer is going to look at that and say, I don't care that this has nothing to do with your job. That's unacceptable. We can't have our employees acting like that. And I'd say that they're well justified in disciplining you up to and including the termination of your employment for cause through that sort of activity. So short answer, yes. Long answer, it depends.
Thank you. And then the next question I had regarding employment is, I was wondering, I've never had this at a job yet, but is it common for employers to have social media agreements in force?
Yeah, so I mean, standalone contracts relating to, social media expectations or conduct, not usually. However, it is very common to have a provision in an offer letter or an employment agreement dealing with the person's expected conduct on social media, right? So, alternatively, you would have something in your employment agreement saying you agree to comply with all the policies and procedures of the employer, as might be amended from time to time. And social media policies are very common these days, and I would say very important, because an agreement is a contract, right? And so it has to have all the typical elements of a valid legal agreement, offer and acceptance, certainty of terms, blah blah blah. But on the other hand, a policy is just an internal document which basically sets standards for expected behavior. And you can't sue for breach of a policy, but it can be used to discipline or to take action on your employees, especially where it's incorporated through your employment agreement. So what you'll most often see is you start a job, you've got your offer letter, it says you'll comply with all employer policies. Your employer has a whole bunch of policies internal, and one of those will deal with social media. That policy will say things like, you will not represent yourself as a representative of this employer organization. If any members of the media contact you about anything to do with your work, you will direct them to management. If you're online posting on any social media, you will make it clear that these are your personal views and not the views of your workplace. And most significantly, you will behave in a way online that is socially acceptable. You will not defame anyone. You will not harass anyone online and these sorts of things. So that's another way that employers can use to get at employees when they do things that are contrary to these policies, even if they're not related to their work. You can be disciplined and suffer consequences as a result.
Thank you. And then I believe this is our last formal question before we move into questions from the public. What can an employee do to ensure that their social media is not used against them in an employment context? I think we touched on that a bit.
Yeah, I agree. I think I sort of covered that. Again, make sure that your account labels you as these are your personal views. Don't list your employer. That's what LinkedIn is for. You don't need to list your employer on Facebook or what have you. And don't use LinkedIn for anything other than work-related stuff. I know lots of people don't exactly follow that, but that's good practice. And at the end of the day, again, going back to what we've talked about multiple times, just don't post things unless you really, really have to. I mean, unless you're an influencer, a public figure, the attention you're going to temporarily attract will rarely be worth it in the end.
Perfect. Thank you. And now let's move into questions from the public. I have a few already. The first is about defamation, so maybe Andrea can answer it. It says, um, it was said that a defamer has to prove validity of comments, but does a plaintiff have to prove damage to reputation? And then the example given was, how do you prove you're not a cheater or an assaulter?
So once defamation is made out, the reputational damages are presumed, which means you don't have to prove that you've actually suffered a loss of reputation. The law recognizes that if you've been defamed, you've been damaged, and so you don't have to do that proof. And the proof of or who is required to prove truth is actually on it's the burden of the defendant. So you don't have to prove that you are, not a liar, a cheat, someone who sexually assaulted someone. You don't have to prove that if you are the one who's been defamed. It's actually up to the individual who defamed you to prove that what they've said is true.
Perfect. Thank you. And then the next one is about employment. So I'll ask Andrew. This member of the public says previously it was a little common for employers to demand social media passwords. Is that still common or legal?
That's interesting. Not if it's your personal account that is completely disconnected from any work. Again, it's an account that, would be like Andrew Skeeth, my Facebook account or something like that. No, that's your personal account. It's essentially your personal property. You don't have an obligation to provide login credentials to your employer unless you're being asked to use it for the purposes of employment. And if that's the case, then you should be creating a separate account for that purpose, labeled with the organization's name or something like that. Now, if they're talking about an account that belongs to the employer, like an email account or some account at organization name, that's different. Anything you do or say in the course of your own work's IT infrastructure is essentially their property, and you really have no realistic expectation of privacy in that context. So in those situations, yeah, it's their account. But if it's your personal account, then no, they have no reason to take those credentials from you.
Thank you. And then another question about defamation, so I'll ask Andrea. If someone is making a post on social media and let's say the court's like calculating damages, if their account was private, would that be a way to limit how defamatory, like the harm caused, because less eyes are on the post?
Yeah, so there are several factors that are considered when you're determining, or when a court is determining damages. Spread is significant, is one of them. Mitigating factors like whether they issued an apology and retraction, which goes back to what I said earlier, that if you quickly correct and apologize and retract, it can limit your damages so much that bringing a claim wouldn't even be worth it. So yeah, the spread significantly is one that's considered. Any sort of especially egregious behavior by the individual who's defaming would be considered an aggravating factor that would potentially increase damages. For example, maybe very obviously, if you are being defamed in a private group chat to 6 other individuals, you are not going to get the same recovery in terms of a reputational damages award as someone who is being got defamed by a national newspaper and is a public figure who is, known to a lot of people. So those are certainly things that are considered in terms of what the damages award is. And so one of the things I often advise people when they're calling is, I say, like, listen, like you've got defamation to 6 or even 10 or just a few people. This is not going to be worth bringing a claim over. Let's figure out a different way to resolve this. And maybe it's just a matter of getting a correction and retraction if that's possible, but it's not worth bringing a claim for just a handful of people.
Perfect, thank you. And then since we have a little time here at the end, the question we skipped over was what can someone do if they're experiencing cyberbullying to kind of prevent it from ever happening in the first place or to stop it once it's started? If either of you could answer.
Sure, I can dive in. I think one of the things that is really important for whether it's cyberbullying or defamation, really any of these online wrongs, is document everything. Take screenshots, make sure that you've got copies of all of the abusive messages or posts or emails or whatever else, because that's going to be the foundation for any claim. And for bringing or providing a cease and desist letter, you're going to need the words of what were stated to be able to base your claim, especially because defamation, for example, requires a certain level of particulars to be pled, and having those particulars is certainly helpful in the form of screenshots. If someone's being victimized online, locking down your own social media accounts can be a really good first step to ensure that people aren't able to use your own content against you. I'm thinking of maybe teenagers, or for example, they're not pulling photos of you that you've previously posted and altering them to help in a campaign of harassment or cyberbullying against you. That's a key way to do it. And frankly, if it's ongoing, as you referred to earlier, there are criminal law provisions that may mean that you can report it to the police for a criminal investigation, or alternatively reach out to legal counsel for a civil matter and see if this meets the test for harassment or defamation. And because often people sometimes engage in this behavior without realizing that there are consequences to this behavior. And it can be a very quick wake-up call to get a letter from a lawyer saying, this is what's happening and it's not okay. And so those are some options that might be available to you.
Thank you so much. And it's been an hour now. So the webinar is ended. I just wanted to let the audience, let's stay connected, find us online and on social media. You can also subscribe to our monthly e-newsletter to get the latest updates on the law and our resources. And please take the time to fill out our 30-second survey when you're leaving the Zoom. And thank you so much to our panelists, Andrew and Andrew. It was really nice to talk to you guys. And I enjoyed myself. It was like having a conversation. So thank you.
Thanks for having us, Megan.
Thank you.